Welcome to History Secrets Uncovered. My name is Jay Chandarana, and today I have the honor of speaking with Professor Christopher Schmidt, a constitutional law scholar and legal historian at Chicago-Kent College of Law and co-director of the Institute on the Supreme Court of the United States. Professor Schmidt's work explores the always changing relationship between protest movement, civil rights, and constitutional change. He's the author of The Sit-ins, Protest and Legal Change in the Civil Rights Era and Civil Rights and American History, and his scholarship examines how ordinary citizens, courts, and political institutions have shaped the meaning of the 14th Amendment and the broader trajectory of civil rights in the United States. Today, we'll discuss how social movements influence constitutional law, how the Supreme Court has interacted with the American public over time, and why understanding the history of civil rights helps us make sense of current debates about rights and judicial power. Professor Schmidt, thank you so much for joining me here today.
It's my pleasure. Thank you.
To start, what first drew you to studying the relationship between protest movements and constitutional law?
Yeah, well, I started my graduate work as in a history PhD program. So was studying United States history, and during the process of learning about history, and I was focusing mostly on 20th century U.S. history, I began to study law and legal development as one of the main themes of my studies of 20th century U.S. history. Eventually, I ended up going on to law school. So I'm in law school studying a lot of what the law is and legal doctrine, but my background interest was always in history and how things develop and how they got that way. So as I'm studying a lot of these famous constitutional law cases, I'm really curious and interested in where these cases came from and what effects they actually had. These sort of bringing these historical questions to the study of law. Then in my last year of law school, I had the opportunity to do a seminar paper, and I recall that when I had taken constitutional law the year earlier, I was really fascinated by these cases that came to the Supreme Court in the 1960s, which were called the sit-in cases. And they had to do with appeals of criminal convictions of civil rights protesters who were protesting racial discrimination in lunch counters in the South, which are racially segregated. So they were launching protests by sitting at these lunch counters, refusing to leave. And oftentimes they were arrested on various charges for these protest activities. Anyway, so in constitutional law, it wasn't a major part of the curriculum, but we did sort of bump into them. There were these cases, and they didn't really fit all that well into sort of the broader development of constitutional law in the 1960s, because the 1950s and 60s was a period when the Supreme Court, under the leadership of Earl Warren, this is the Warren Court era, was really pushing quite aggressively in support of the civil rights movement in cases like Brown versus Board of Education, striking down segregation in schools, Loving versus Virginia, striking down anti-interracial marriage statutes. These really big landmark cases, the court was squarely putting constitutional law on the side of racial justice and civil rights. But then they had these sit-in cases, and they were sort of stuck there in the early 1960s. And there were cases that the Supreme Court, they decided them in favor of the protesters, but they really struggled with these cases. And they decided them on very technical grounds, and none of them really turned into a major landmark decision in favor of the principle of civil rights. So I was just intrigued by these cases because as a historian, they didn't quite fit the larger narrative of what the court was doing at this time. And I was just trying to figure out what's going on here. So anyways, this became the topic of a third year law school seminar paper on the sit-ins, with my question being about trying to study how social movement activism, in this case, the lunch counter sit-in movement of the early 1960s, influences or fails to influence the development of constitutional law and constitutional doctrine. So that was a question I had, started researching it, and just became fascinated by it. It went from a seminar paper to a handful of articles and then eventually into a book.
That's really cool. And earlier, you touched on the court case, Brown v. Board of Education, and that is probably one of the court cases students learn the most about in the public school system. And many students learn about Brown v. Board as a turning point, but your work shows that change didn't happen automatically after Brown. What did reality actually look like in the years that followed? How was that progression?
Yeah, great. Yeah, yeah. So Brown is, one of the most important, perhaps the most important decisions of the Supreme Court in the modern era, perhaps in its whole history. And it's a massively important decision, and it really was a turning point in a lot of ways. But there's a couple ways in which Brown, sort of surprises. It differs from that storybook version of the Supreme Court stepped in, and all of a sudden schools are desegregated. 2 points. One point is that Brown actually was very ineffective at actually doing what it was supposed to do, which was to desegregate schools in the South for like a decade. So Brown was basically a non-entity in the Deep South in the years directly following the decision, which was handed down in 1954. All right. So Brown, in some ways, failed for a period of time, and it wasn't until the mid 1960s, sort of at the tail end of my sit-in story, that you actually have real desegregation taking place in the South. So that's point one. Point one is that like it didn't really do what it's supposed to do. Point two, deriving from that point, for members of the civil rights movement, for activists in the civil rights movement, Brown was really, in some ways, sent quite mixed messages. Again, the storybook version is Brown was inspiring. The Supreme Court was on their side, and that was great. And there was a lot of that, right? There was a lot of the sort of the Brown did help show that the court and, the law was on their side, which, I think most racial justice activists assumed law was on their side if just the, courts would read it correctly.
Yeah.
But that was a pretty powerful message. But Brown was also quite disillusioning to a lot of people for the reason I was just talking about. Brown announced this great promise, racial segregation no more, at least in schools, but eventually was expanded to any public facility. But then what happened after Brown? Nothing, right? So the generation of students who were led to sit in protest, the protagonists of my story, if you think about the age they would have been, so most of the people who were leading the sit-in protests were in college. So they're in college in 1960, 61. They would have been in middle school to high school when Brown came down 6 years earlier. They would have heard about Brown, of course. They would have heard about all the high hopes that Brown included. They would have expected that now that Brown came down, the world is going to change. I mean, the Supreme Court declared this is unconstitutional. But what happened? Nothing. Most of them who were attending Southern schools attended segregated schools before Brown, and they continued to attend segregated schools after Brown. Now, this is important for my story because Brown, which is, inspirational in some ways, it also created disappointment and frustration because it failed to actually have an effect on the ground for these people's lives. And therefore, when they decided that they wanted to step up and take action, they're in college, they decided they wanted to attack racial injustice around them, they didn't call up the NAACP or some civil rights lawyers. They didn't talk to the legislature. They decided to take things into their own hands, and by using their bodies, just sitting at these counters and just refusing to leave. So what they did was in some ways both inspired by Brown, but it was also a critique of Brown because Brown failed to deliver and they were going to try a different tactic. So the sit-ins need to be seen as in some ways an alternative to using law, lawyers, litigation, courts. They thought that that didn't quite achieve what it's supposed to do, and they're going to try something else. And they weren't going to wait and talk to lawyers. They were just going to take things into their own hands. So Brown is a huge factor, a background factor for the story that I tell, picking up in 1960, 6 years after Brown.
And before we move on to sit-ins, about Brown v. Board, would we consider the failures of Brown to be in part not because the law wasn't clear in Brown, because it did clearly state that the segregation in school was unconstitutional, but the way people at that time responded to it, specifically like white superintendents who would use scare tactics still to prevent black students from entering schools. I mean, what's the story behind that?
Yeah, so it's a really great question. I will say the law of Brown is clear, which is racial segregation in schools, mandatory racial segregation in schools, segregation policies in schools. You need to be sort of careful with your language here. When schools are ordering racial segregation, that is unconstitutional, violation of the Equal Protection Clause of the 14th Amendment. That comes out quite clearly May 17th, 1954 in the Brown decision. Now, one thing that's important to know about Brown is that the Supreme Court announced the Brown decision in 1954, but they didn't announce how they're going to implement the decision. So segregation in schools unconstitutional, but exactly how that ruling was going to be put into effect in the schools, which across the South were segregated. I mean, it's a massive upheaval we're talking about to put it in line with the Constitution. But they said, we'll come back, we'll have arguments next year, and then we'll have another decision. And the second decision will be an implementation decision. So then you have what's called Brown 2. Brown 2 is decided a year later, 1955. In Brown 2, the court does not impose a real strict timetable for implementing Brown, for desegregating schools. They say we're going to hand off responsibility to lower court judges. The Supreme Court gives responsibility down to the federal district courts, which are the sort of local federal courts, because they say there's different circumstances in different jurisdictions, and we want the courts to sort of guide these jurisdictions toward desegregation. And we're not going to have strict timetables. There's this famous line in Brown 2 saying that desegregation needs to take place with, quote, all deliberate speed, which a lot of people at the time sort of saw that as just sort of empty words because, it's a little oxymoronic. Deliberate is slow, speed is fast, all deliberate speed. Like, what does that mean? I think it was purposely chosen by the court to not be all that meaningful and strict because they wanted to have flexibility. Now, when they issued that opinion, they assumed that flexibility would allow school districts some latitude, but ultimately they would have to move toward desegregation. This is where we kick in what you were referencing, which is okay, so you have a Supreme Court decision which is quite clear on the law, but quite open on the remedies, the implementation of the law, combined with what happened in the response to Brown and Brown 2, which is the white South mobilized against it, right? So they come out, the white Southern politicians who are in control, and they fight Brown. They denounce Brown, sometimes quite explicitly, and they say, we're not going to fall in line. This is something that's called massive resistance, this sort of campaign of resistance against school desegregation. And they put up a fight. At first, it's a very explicit, open fight. And then eventually it becomes a fight where they're no longer denouncing Brown and desegregation, but they're using tactics like intimidation, like slow walking implementation, token desegregation, to try and have as slow a process as possible. So they have all these tactics. So the combination of a implementation that was left open, and probably even more significantly, the fact that the white South mobilized against it. And this is an old story with the court. The court is very powerful in many ways, but it doesn't have an army. It doesn't have police forces. And it really needs to rely on other people to step up and implement their decisions. And when the white South, who had power, were really aligned against Brown, there wasn't a heck of a lot they could do, which is how we get the situation I was describing in 1960, which is Brown was pretty much a non-entity on the ground in the South because of this concerted resistance and the inability of the court to really follow through. And the court just kind of stepped back and was sort of waiting things out, right? Again, they knew that they were limited in some ways. They had their decision. They were not going to back off of the decision. It was a 9-0 unanimous decision. They were not going to move from that decision. But I think they're kind of hesitant to try and assert authority, which they didn't really have. So they sort of backed up a little bit. But as my sit-in story tells, that did open a bit of a window. A window opened up by a lot of raising of hopes and frustrations. And then what you see happening in the aftermath of Brown is people exploring alternative pathways to social change other than litigation. I mean, people kept litigating, but then people were really more aggressive looking at other ways in which you can try and advance racial justice causes other than getting courts to decide in your favor, because that was shown to be limited.
And while we're talking about social change, in your book, The Sit-ins, you argue that these protests didn't just put pressure on courts, but it actually reshaped the legal landscape almost in its entirety. How exactly did student activism kind of influence the development of the Constitution?
Yeah, so this is a really fascinating story, and this really gets at what I was talking about a while back, where I was just really fascinated at the beginnings of this project with how social movements can influence the development of the law, right? And the basic way in which this happens is a lot of our constitutional law, particularly our constitutional law that relates to these sort of broad provisions in a constitution, things like the Equal Justice Clause of the 14th Amendment, which is at the heart of my book and the heart of the sit-in story. It's pretty broad language. There's a lot of flexibility in terms of what the court can do with that language. And basically, history shows us that how courts interpret the meaning of these broad constitutional provisions, including the Equal Protection Clause, is informed by their understandings about how the world works, what's right and what's wrong. So, a really easy example of that would be in 1896, going back into history, but 1896, the Supreme Court hands down a decision called Plessy versus Ferguson, in which they say that mandated racial segregation by states is constitutionally permissible. It does not violate the 14th Amendment. So basically, segregation is constitutional, right? That was for the court at the time, the world they lived in, that was seen as not an unusual thing, that segregation was part of the era in which whites breathed, and it was just not seen as a deeply unjust decision from their perspective. Flash forward to 1954, the Brown decision we've been talking about. By that point, you have nine justices who no longer see that as a normal state of affairs. They see racial segregation as deeply unjust. I mean, they struggled with the decision because anytime they overturn precedent, anytime they issue this a decision that's really going to disrupt society, the court's going to be hesitant. But across the court, they all knew it was deeply unjust and wrong to have racial segregation. What happened? Social change happened. I mean, just society was much different between 1896 and 1954. So that's just an example about how changes in society, which are oftentimes deeply shaped by social movement activism, can change just the assumptions about how society works, about what is morally correct and morally wrong. And those assumptions, those beliefs, will eventually infuse how judges understand the open-ended provisions of the Constitution. That helps explain why Brown happened in 1954, even though it, was a very different from what happened before that.
That's really
So,
interesting.
in
Oh,
my
sorry.
yeah. No, no. So I was going to, so then just moving forward to my sit-in story, that's sort of, sorry, a little setup. In the sit-in story, the main challenge for the court was this question about where the 14th Amendment actually applied. Because by the time the sit-ins happened in 1960, the court had already decided racial segregation is unconstitutional when the government does it. So that's why racially segregated schools are unconstitutional. And they struck down racial segregation in publicly owned golf courses and swimming or public beaches, in all these places where you have the government running, making the choices, no more segregation. That's what Brown and the follow-up cases that Brown said. The sit-in cases were a little bit trickier, and they were trickier because the places that were segregating were not run by the government, right? They were private businesses. Like the Woolworths was a lunch counter, private business. So the question is, does the non-discrimination requirement post-Brown of the 14th Amendment, is it going to apply not just to publicly operated facilities, government operated facilities, like a cafeteria in the basement of a courthouse? Can't segregate that. But what about a cafeteria placed within a private business, a lunch counter? That was a hard case. And what I argue is that the sit-ins, the protests of the sit-ins, by putting on display for the entire country the injustice of this particular form of racial discrimination, really did help move public consciousness in a broad sense about the rightness and wrongness about this particular form of racial segregation, which is racial discrimination in businesses. And that did help move the court to rethink about maybe the 14th Amendment should apply in this particular context. Now, in the end, the court didn't fully buy that, and that's part of what the story I tell about why the court struggled with that. But that's just an example about how social movements and the kind of display that the sit-in protests put on for the whole country could help change assumptions and norms about right and wrong, justice and injustice, discrimination for sort of for the public at large, and how that can eventually pressure and maybe change how the Constitution is interpreted, because the Constitution, or at least certain parts of it, are really informed by these broad assumptions in society.
Yeah, so I'm currently working on my own paper about the Appalachian meeting in 1957, where where the New York police accidentally discovered the American Mafia. And one of the things I kind of emphasize in that work is that it's not much about how that specifically changed federal policy, but more about how it kind of exploded into a public mess. and launch the mafia into the public sphere. Do you see the sit-ins
Mhm.
almost in a similar way, where the actual legal change isn't there immediately? It may have come out of a response to public outcry, out of a public kind of acknowledgement of the situation that's happening.
Yeah, so it's a really complex dynamic to think about how legal change actually happens. You have sort of social protest, which social protest in some way is responding to law, like the state of the law, but then they're also pressuring the law. Sometimes you have law actually changing directly because of it. Sometimes you have just social practices changing. Sometimes you just have a public response, right? It could be exposure. And a lot of this was exposure. There's a lot of people in the North who simply weren't aware, right, of what was going on and just hadn't really thought about it. But once the sit-ins make this a major public event, once it's all over the newspapers and all over, the evening news, then people start thinking about it differently, right? Now, what happens there can go in lots of different directions, right? You may have legal change, you may not have legal change. In my story, you had pressure on the courts, but no fundamental change in constitutional doctrine by the courts. But eventually, you had Congress getting into the story. So my story is very much about how courts can do some things, but also how legislatures can also step in, right? But I will say that even if my story didn't eventually lead up to major piece of federal legislation, we're talking about now the 1964 Civil Rights Act, which prohibited racial discrimination in restaurants and hotels across the country, eventually, essentially answering the problem of the sit-ins. Even if that didn't happen, right? Even if there wasn't this formal legal change, the exposure of the problem would have changed society, right? It would have been a much messier process. The law helps sort of makes it more universal, the application of the new social norm. So what you're talking about, yeah, just sort of getting something, a protest or an action that gets something into the public sphere, makes people aware of it. It changes the lay of the land. And that lay of the land may result in legal change, but it may result in something else, right? So it's sort of there's all sorts of offshoots you can imagine going in different directions. And, this is a wonderful thing about history. Every story is distinctive, right? There are patterns, but they're not really set, and everyone's a little bit different.
Yeah, and we just touched on the idea how courts didn't always lead directly to change. And in your article, Divided by Law, you kind of talk about that and show how courts sometimes slowed or complicated the civil rights movement and civil rights progress. Can you explain how litigation, in some cases, could both advance and constrain the movement?
Yeah. So, it's a really important question for people who are interested in social movements and law. Sometimes social movements and law works in conjunction nicely together. I'd say like the lead up to Brown versus Board of Education, you generally had people fighting against segregation. You had lawyers arguing cases in court, and it was generally seen as working on the same page, and that achieving a legal victory really did help advance the cause. Now, when you get to the civil rights movement, the racial justice protest struggle of the 50s and 60s, it gets a little bit more complicated because you have a lot of efforts to create social change in ways other than through litigation, right? This is sort of the story I'm telling about these students. But sometimes there's some tension between protesters who are trying to do direct action protests, meaning just going out there and demanding rights, getting attention, trying to pressure change directly, and lawyers who have their own way of doing things. I mean, lawyers like to have nice, clean cases they bring to court. They like to have the fact patterns that they can rely upon. So there's this fascinating episode in my story where the students launched their protest, and they did so without consulting lawyers. They just went out and did it for all the reasons I talked about. But soon after they did it, they started getting arrested, and they actually needed some legal assistance. Civil rights lawyers, including some lawyers from the NAACP, which was a major racial justice litigation arm at the time, come down. And Thurgood Marshall, the great civil rights lawyer who had argued Brown versus Board of Education, basically tells the students, like, okay, good work, kids. You can go home now. Let me take over. And for the students who are like, you just don't get it. Like, our whole purpose is that we want to continue to protest. The protest was very empowering for us. We were getting a lot out of it. We were making change happen on the ground. From the lawyer's perspective, they think that the only way you're going to create lasting change is you actually need to change the law in this formal way, meaning you win court cases or you send members to Congress to lobby for change. So there's just a different vision about
Got
how
it. Yeah.
change could happen. There's some tension there. My story says the tension, they figured out a way to make it work. The students kept protesting, the lawyers had their cases, and they did it. But there are sometimes situations where protesters and activists can feel disempowered by lawyers. Lawyers try to take over. There's situations sometimes where lawyers feel like activists are making their life harder, making it harder for them to win cases because sometimes they're doing activism in ways that's, making their legal arguments more difficult to pursue. So there's possibilities of tension between people who are oriented in litigation, legal change versus protest. We see this in the sit-ins. We see them sort of working through their problems, but this is really a pretty common issue when you study um, social movements and lawyers.
Now, we talked about kind of the tensions between protesters and lawyers, but would there be the same kind of tensions built between activists who trusted the court system and trusted these lawyers versus activists who believed that change had to happen outside of the legal system entirely?
Yeah, so there have been situations in which that's happened. I will say in my case, there wasn't a lot of that because ultimately the sit-in protesters could keep doing what they were doing. I mean, again, the glory, the genius of a sit-in protest is it costs nothing other than just being able to walk downtown to a store when they had, these downtown stores. So it's and all you needed was a handful of friends. I mean, that's why it took off across the South. I mean, it really was a protest that started kind of small and just spread across the South because it's so easy to pull off, right? Meanwhile, the lawyers had their appeals and they could pursue their appeals, and generally they were sort of running on sort of parallel tracks, doing their own thing. So there wasn't a lot of sort of protesters who are with the lawyers and protesters who are against the lawyers. They were kind of doing their own thing. Um, and one thing about litigating is that pretty quickly you have an action that sort of sparks the protest sparks the litigation, and then it quite quickly just sort of it goes off on a different road, right? I mean, there's this interesting story I picked up as part of my book where one of the major cases the court decided is a case called Bell versus Maryland. It got to the court eventually decided in 1964, and Bell, the protester whose name was at the top of the court case, didn't even know his case was getting argued in the Supreme Court because it happened years afterwards. He actually had gone off to law school himself. So again, they're going on these different tracks, and they were able to sort of come to an arrangement where they could work, do their own things. But again, there are some other protest movements in which there's sort of more close working relationship between protesters and lawyers, and that can create some tension. I mean, there's definitely some opportunities for tensions, which is why lawyers need to be really attentive to who their clients are and what they want. And sometimes there's that sort of translation about taking a protest claim, and making it into a claim that can win in court, and that can be a difficult process sometimes.
Yeah, that makes a lot of sense.
Yep.
Yeah, and kind of moving on from that, you've written about how the Supreme Court justices communicate with the American public. How has that relationship and dynamic changed over the last century?
Yeah, so that's a big story because that's pretty much the topic of my new book project.
Nice.
Um, this sort of simplified arc that I'm trying to tell is that over the past century or so, the Supreme Court has become a much more prominent part of American politics and public life. The court has always been very powerful and influential, but usually it was sort of a separate institution that people didn't really know a lot about, people didn't really think about. Uh, you know, Presidents would appoint justices. Generally, it wasn't all that controversial. The decisions may or may not be controversial, but the court itself as an institution wasn't usually a target of big political debates. People admired the court. They didn't have these really high hopes or fears of the court. And what we see happening over the past century is the court has sort of become closer to the people, more a part of their lives. Politicians talk about the court a lot more than they did in the past. Political campaigns by presidents are now campaigned with the court being a campaign issue, promises to appoint people of certain kinds. Confirmation hearings are a moment where you have new justices who are brought into your living room. You can see them, you can get to know them. There's hugely contentious arguments about them. People are much more aware of who's on the court. Small opinions get a lot more press. So there's just a lot more attention, and that attention is very, it's kind of a mixed bag for the court because a lot of it's quite critical attention. And the court is just simply more part of our politics, more an issue for social movements, for interest groups than it was in the past. So a lot of it is about how the court has just simply become more integral to American politics than it was at past moments.
And connected to this kind of growth of publicity for the Supreme Court, um, many Americans today kind of question the court's legitimacy. And historically speaking, is this a moment kind of that's unusual, or is it part of a larger repeating pattern? Because we often see a lot of trends repeat themselves in history.
Yeah. Um, so it's a little bit tricky because you need to figure out what exactly we're talking about by legitimacy. Sometimes legitimacy is sort of used for shorthand. Do people have like confidence and faith in the court? Um, and by that measure, there have been the last 10, 20 years, the public confidence in the court has dropped. It actually used to have some pretty robust public confidence. And then in the last decade or so, particularly after the decision overturning Roe versus Wade, sort of public support for the court has dropped, right? So that may be one measure, a rough measure of legitimacy. Another measure of legitimacy is, do people follow the court even when they don't agree with what it says? And by that measure, there have been past moments in our history, particularly back in the first 100 years of the court's history, where there are court decisions that were widely defied, ignored, pushed aside. We talked about Brown. Brown's an instance in which the court decision was defied by much of the country. But as controversial as the court has become, compliance with court decisions has become, in some ways, more accepted. So this is why just sort of exactly what we mean by legitimacy is a little bit complicated. The court in some ways is much more controversial, much more disliked than it has been in the past, but the court in some ways is much more powerful than it has been in the past. And Donald Trump gets a decision against his tariff position and he complains about it, but then he quickly complies with it, right? And there have been some past moments where presidents haven't necessarily been so willing to comply with decisions that go directly against what they're trying to achieve. So it's just, history is complicated. There's been ups and downs, and it's not a clean trajectory one way or another. The court has always been contentious, but my argument is as contentious in different ways today than it has been in the past.
And kind of on a somewhat similar note, when we talk about the Constitution, specifically amendments to the Constitution, one of the most popular is the 14th Amendment. Of course, we have freedom of speech, freedom of religion, we have the woman's right to vote, but the 14th Amendment gets cited a lot, especially around cases with equal protection and civil rights. And my question is, are we still arguing over the same questions that were unresolved during Reconstruction in the 1960s? Or has the way that the 14th Amendment is now interpreted and used shifted in a new way?
All the above. So in some ways, the questions are quite similar. I mean, the interpretation of the 14th, like what does the 14th Amendment mean? The due process clause is the other major provision. I teach constitutional law, and 2/3 of my constitutional law course is taken up by the 14th Amendment. And it's pretty much
Yeah.
by the two clauses, the due process and equal protection clauses. So yeah, the 14th Amendment is by far the most significant provision of the Constitution and the one that's produced the most significant litigation. Some of the questions are quite similar. I mean, there's just some things that we simply haven't resolved about the nature of inequality, what liberty is. There's some cases that are still are based back in the 50s and 60s that are still quite contentious. There's some issues, that were at some level in the air at the time of the drafting of the 14th Amendment. Having said that, of course, we are in a very different world today than we were then. We're talking about, recent cases have to do with whether the Equal Protection Clause protects us against discrimination for transgender individuals, for sex-based classifications. These were not on the agenda in 1868, or at least not on the court's primary agenda, right?
Yeah.
So there's some of these sort of the same principles and concerns about equality and liberty are still with us today. Some of these questions sound, very circular. We keep going back to them. but they're applied to different situations, and sort of different answers can come out over time. So, the historian in me would just say that it's a story both of continuity as well as disjunctures and new developments and change over time. We can see both those things happening. And the 14th Amendment is a great vehicle to sort of see how both those things work together.
Now, when Americans are asked generally what makes America so great, a common answer is always freedom and liberty. As a professor of constitutional law, do you think those words are overused? And do you think there's something special about the Constitution that protects our liberties and protects our freedoms in a way that other countries don't have?
So, Um, I would not say that they're not used too much. The words freedom, liberty, equality, justice, I think these are very powerful terms. They don't really get you too far, as in all sides will claim to be fighting for freedom, liberty, justice, and equality. So it's not like that can really define you against an opposing argument, but those are very powerful principles and terms that do tap our current battles into these deep principles that have been part of our constitutional tradition for a long time. So I think it's really important when you're arguing for change and you're trying to change the world around you to connect it up to past struggles to change the world. And these terms can do a lot of work to do that. They sort of this like connective tissue across time. I think are really powerful and important, right? I don't think that the words of our Constitution are so brilliant or exceptional that that really makes the United States different. What I do think is that the national commitment to the Constitution, the way we've used the Constitution, the way we've really put the Constitution at the apex of our principles, all the hopes and values we put into our Constitution. So it's not just mere words, it's what we've done with those words in that document. That is exceptional. I mean, the American reverence for its Constitution, and again, not just words, but it's the principles that sort of come out of those words. That does, as I understand it, separate us, the reliance we put on our courts to play a leading role interpreting the Constitution. That does seem to be somewhat different, right? And the faith that our Constitution is going to sort of connect us across time, because it's a very old Constitution. It's a lot older than most other constitutions. So the age and respect and reverence for the Constitution as an idea, as a principle, I think that's really special.
Yeah, thank you for that. That yeah, that's super insightful. And kind of a final question. If you had to explain to high school students like me why studying the history of constitutional change matters, what would you say?
Yeah, so I think I have a straightforward answer to that, and this is always where I end up my constitutional law class. And that is if we understand how past generations have changed law or protected law, right? And we understand their struggles, it helps empower us today. That if you don't like the way the law is today, or if you're trying to fight to protect the way the law is today, you can get a lot of guidance and inspiration and hope from past generations, right? That the law is constantly changing and it's changing for reasons, and those reasons we can learn about. And they don't give you like rules. Like it's not just sort of like you need to know like the hack to get it done, but they do give you examples, and examples are really empowering. So I do think history, when taught correctly, is empowering. It tells you that we've changed before, we can change again, and it shows you how change has been done in the past. And if you're interested in making change, like there's no better grounds to like think about it and to study it than our shared past.